This is being live streamed, just so everybody knows that I'm required to do that under the rule that courtrooms are open to the public. I just wanted you to know you can, well, your name is on the screen. I was going to refer you just as Kayla, but if you prefer, you can turn off your video. It's up to you. I just wanted you to know that.
Okay, thank you, Your Honor.
You're welcome. This is People of the State of Michigan versus Devin Stone, docket number 20-500FH. This is the time set for sentencing. First, Mr. Stone, would you confirm that you agreed to do the sentencing remotely?
Yes, I do.
Thank you. You were convicted of capturing or distributing an image of an unclothed person. That is a felony, punishable by up to 5 years in prison. You have the right to an attorney. You are represented by Ms. Lehman. And Ms. Lehman, have you had a chance to review the pre-sentence report with your client?
Good morning, good afternoon, Your Honor. Marielle Lehman on behalf of Mr. Stone. Yes, we have reviewed the pre-sentence investigation report. There are no additions, corrections, or deletions. I did include some comments in my sentencing memorandum, and then I believe I just have a couple when Your Honor is prepared for me to present those.
Yeah, we'll get to those, but thank you. No corrections to the report, and then does that mean no objection to the scoring of the guidelines either?
That's correct, Your Honor. I did calculate them myself, and they are scored correctly.
Okay, Mr. Duane, do the people have any corrections to the report or objections to scoring?
No, Your Honor.
Okay, and then there is a victim who wishes to be heard, correct?
That's correct, Judge.
Okay, Ms. Ward, you may go ahead.
Good afternoon, Your Honor, and thank you for allowing me to speak. I did submit a victim's impact statement today to the prosecuting attorney and also victims' rights. I just wanted to make sure that Your Honor has received that, and then if it is okay with the court, I would like to read that.
Yes, I did receive it. You may go right ahead.
Thank you, Your Honor. My name is Kayla Ward. I'm an Army National Guard veteran and currently a court officer with the 12th District Court in Jackson, Michigan. The defendant and I dated for 2 years when we were both in high school, and again briefly several years ago. I'm now 27 years old. I've been married to my husband for 1.5 years, and we're proud parents to our son who recently turned 5 months old. The year 2020 was a year of blessings for our family as we learned that we were to become parents, but it was also a year of hardship, in part due to the COVID-19 pandemic, but also due to the transgressions committed against me by Devin Stone. On December 6th of 2019, I received a text message from my cousin-in-law at 4:48 p.m. asking me to call him when I had some privacy. I recall reading this message as I was getting ready to come home from work that afternoon, and I knew whatever this was regarding that I needed to call right away. On the walk to my car, I discovered that photographs of myself had been uploaded to a foreign porn site called motherless.com. I remember the immediate feeling of shock that I had. It's hard to describe other than a rush of cold down the spine, and all of a sudden the world around you doesn't seem to exist. I remember a rush of questions I couldn't answer. How could someone do this to me? How long have these pictures been up? How many people have seen them? It felt like the weight of the world was crashing on my shoulders. I returned home to my husband, who immediately knew that something was wrong. Despite him being the most loving and supportive person in my life, I found myself unable to speak and barricaded myself alone in our bedroom, unsure of what to do. I must have been in our bedroom for a good hour before I was able to reveal to my husband what I had discovered. And from that point, I contacted dispatch requesting to file a police report. On the site, I discovered that 59 pictures of various women, including myself, had been uploaded under a user's profile who went by the name of, quote, freak6969, end quote. On the profile, I found pictures of myself with hashtags including hashtag ex-girlfriend, hashtag teen, hashtag nude, and a list of other explicit hashtag descriptors. I found that most, if not all of the pictures had been uploaded in February of 2019. The formatting of this website allows viewers to see how many people have seen and liked each individual picture uploaded, and it markets itself with the phrase, "Go ahead, she isn't looking." I found one image of myself that I was lying face down on a bed, clearly asleep and unaware that I was being photographed, and this image had 230 views. An additional picture had been taken of me that clearly showed my face in the view with my eyes closed, It was titled Sleeping, and even more disturbing, it had the descriptor of #daughter. As if that wasn't enough, I found an image of my genitalia that had been taken when I was asleep on my stomach. You can see Mr. Stone's thumb in the image had been used to expose my labia. The image was titled Sexy Teen and had a descriptor of #ex-girlfriend and #sleeping. I want to make it clear to the court that I never consented to any of the aforementioned pictures being taken, nor had I known that they even existed until I was made aware of the site. I'd like to take this time to address Mr. Stone directly. Devin, these photographs have been off for 9.5 months before I knew the site you posted them on. I'm thankful that I was notified, but the timing couldn't have been worse. I'm sorry. 3 weeks after we were made aware of these pictures, my husband and I found out that we were expecting our first child. Because of what you did, I didn't get to have a single day to be able to truly celebrate and plan for the future of my son without worrying about these pictures surfacing somewhere, or whether or not you would be held accountable for your actions. There were images on this site which I believed were of your current girlfriend. After I made contact with law enforcement, I wanted to ensure that she knew as well. I asked the responding deputy if I could send her a message on Facebook, as I believed she too was a victim of the crime you committed against me, and he indicated that that would be fine. I messaged her on Facebook that night, and the following morning I found that her Facebook account had blocked mine and that the account Freak6969 on Motherless had been removed by the user. You'd been caught, you knew that you had been, and you were trying to cover your tracks. Thankfully, Detective Freeman and others from the Jackson County Sheriff's Department were diligent in their efforts and were able to verify what I knew to be true. Even though you deleted your account from the original site, these pictures still linger elsewhere. I can hope that they aren't found by another family member of mine again, but there's no guarantee. Once something like this is posted on the internet, you can't take it back. Excuse me. You violated my trust and my privacy. You took pictures of me while I was asleep, none of which I would have ever consented to, and then you posted them for the world to see. I have no idea what your motivation for doing this was, but I have no doubt that you never thought you'd receive any consequences for your actions. You clearly don't care about how it would impact me. You clearly didn't. And despite your complete culpability in this, your reality is one that is a little more optimistic than mine in the long run. I'm confident in Agent Spears' commitment and ability to ensure that you're held to a high standard throughout the term of your probation, and that he will seek for you to engage in services for the betterment of yourself. I have little doubt that you complete all terms of your probation and that you will successfully be discharged. You have the faculties and the resources to do so. Someday, you'll be eligible to have this offense expunged from your permanent record, and I doubt that you will lose your job as a result of this conviction in the interim. You will not serve any time incarcerated for this offense unless you violate your terms of probation. I, on the other hand, have to live with the reality of the situation that you created, that there are identifiable, naked pictures of myself online just waiting to be found by someone else I know. I hope that this experience leading up to today and these consequences for your actions are enough to ensure that you never reoffend. And beyond that, I hope that you learn to think beyond yourself someday. My hope for you is that you learn to regret what you did based on how it has impacted me and any others you may have wronged, rather than how it has impacted yourself. Thank you for the court's time, Your Honor.
Thank you very much. I appreciate your comments. Mr. Duane, did the people wish to be heard?
No, Judge, I can't follow that up. She did an incredible job.
Ms. Lehman, I'll hear from you.
Thank you, Your Honor. I will keep my comments brief, as I did file a sentencing memorandum that I trust that the court has reviewed. One thing I failed to address, Your Honor, is while Mr. Stone has been on bond, he has been allowed to travel for work-related purposes so long as he verifies it with pretrial services. I would ask that the court continue that allowance while on probation without having to file a motion with the court to request that travel, as sometimes the travel is a week or two. He's advised a week or two prior to being told he has to travel interstate. So that would be the first thing, Your Honor. I do know that Mr. Stone would like to address the court and Ms. Ward as well. He has a very brief statement to make. Lastly, I did advise Mr. Dwayne about this issue. Your Honor ordered that Mr. Stone do DNA testing. As a result of COVID, none of the facilities are doing the DNA testing. So he is following up on it, but he has not been able to comply with that. He did indicate to me that he was on the date of his arrest. Sorry, Judge. He did indicate that.
No, I'm sorry. I had to mute the jail. Go ahead. I'm sorry.
He indicated that he was DNA tested on the date of his arrest. So he's not sure if that satisfies the court or not. He will continue trying to get the DNA testing done per the court order, but because of COVID, he has to go to Jackson, I think it is. He has to go to Jackson County, and Jackson County has indicated that they're not doing it. Based on our conversation. So I did let Mr. Dwayne know. I have had this issue in other cases in Oakland and Macomb County as well, where the health departments and various agencies aren't doing the testing. So I wanted to make the court aware he is trying to comply with that order, but has not been able to yet. So in closing for my argument, Judge, I would just ask that the court adopt the recommendation with the requested modifications in my sentencing memorandum and in accordance with the Cobbs and Killebrew agreement, as that agreement was reached after Mr. Dwayne had extensive conversations with Ms. Ward.
All right, thank you. And now you, Mr. Stone, what would you like to say?
Your Honor, I want to start by saying that I know what I did was wrong, and I'm truly sorry for that. I'm sorry to Kayla in particular. I had a major lapse in judgment when posting those pictures, but it was never meant to be malicious in any way. At the time, I did not think how it would affect Kayla, and I'm incredibly remorseful for the negative impact my actions have had on her life. If I could, I would go back in time and never post those pictures. I've spent the last year thinking about my actions, and I know that I'll never do anything like this again.
All right, thank you. Well, I always appreciate having victim impact statements at sentencing. I rarely go into any detail directing any comments directly to the victim, but I have to say to Kayla, your bravery and your dignity with which you've handled this is just incredible. It is incredible. I admire you. It's wonderful.
Thank you.
Unfortunately, you are correct that your bravery and your dignity, if you weigh it on the one side, will not equal the consequences to Mr. Stone. And he frankly deserves far more. Now I'll say I agree to no upfront jail as a Killebrew or as a Cobbs agreement. And then the prosecutor followed my lead and did the Killebrew to no upfront jail. I will go along with that still. But what I did not know at the time that I think is really important to mention here is I thought that these were pictures posted without your consent to posting them. What I've now learned is that the photos were taken without Kayla's consent or knowledge. So she wasn't just violated by the posting of the pictures, which is bad enough, but she was violated every time that someone looks at them. But she was violated by the taking of the photos to begin with, because she did not know or consent to any such photos. So that makes this, Mr. Stone, an extremely egregious violation. Honestly, you should be ashamed of yourself. You should be humiliated by this, by what you did. You know, I often tell people on other types of offenses, just let the shame go, let the humiliation go, you know, focus on healing yourself and improving yourself and making things better instead of being stuck in shame. And I think you don't have enough shame. You don't have enough shame. How could you do this to someone? Take pictures like this of this woman when she's sleeping and post them for the whole world to see? I don't care if it happened 2 years ago. It is terrible. It is inhumane to do that to someone. But I understand why, things get negotiated the way they do. And like I said, I am willing to go along with this. But I think that you need stringent terms of probation. I'm not going to ease up on the probation terms. I'm going to impose the most stringent ones that I can. And I read the sentencing memorandum, and some of these, they're just not applicable, I agree. But others I want to explain myself on. So first of all, we've got the requirement that Ms. Lehman contested about signing the MDOC Internet Use Agreement. The Internet Use Agreement, in case you haven't seen it, is not quite as onerous as you might think. It basically requires that he has to provide an inventory of all his electronic devices and allow access to social networking sites, not use or access social networking sites without prior authorization from his agent. He has to basically make his passwords known on his computer so that if the agent sees a need to do, and in this case very well could, they can access his personal devices. I've never interpreted that to apply to his employer's devices. So I am going to require that internet use agreement as a condition of probation. The next one was, you may not purchase, possess, or use sexually stimulating materials of any kind. The defense felt that was not needed. I think it's needed, especially now that I learned the circumstances under which these photos were taken. And 1.5, you must complete sex offender treatment. If I didn't know about the photos and the way they were taken, I might say, oh yeah, maybe he doesn't need that. I'm more convinced than ever that he needs that. You may not possess or use any photographic equipment or photographic development equipment. The defense says, well, that could prohibit his cell phone. I don't think so. I think that's directed towards, it sounds old fashioned, but a camera where people develop the film themselves. And I think that, it's directed towards sex offender types that might do that in order to circumvent being, discovered. So I think that is pertinent. Comply with alcohol testing and drug testing, etc. I understand that there's been no reported abuse of alcohol or controlled substances. However, they lower one's inhibitions and make one more prone to engaging in antisocial rather than pro-social conduct. So I think those are called for as well. Complete outpatient or residential substance abuse treatment, I had no intention of ordering. It's not called for. They just put things on there that are optional if it's called for by the facts of the particular case. And then the other one was the prescription medication one is not called for. So Mr. Stone, I am placing you on probation for a period of 24 months, 1 day in jail with credit for 1 day served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $720 payable at the rate of $30 a month, cost to the county in the amount of $500 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County. And then additional conditions of probation are you may not access the internet using any of your personal devices without first completing and signing the MDOC Internet Use Agreement. You may not use any telephone numbers or telephone services that are sexually oriented. You must not purchase, possess, or use sexually stimulating materials of any kind. You must complete sex offender treatment when you're referred by your agent. You must not possess or use photographic equipment or photographic development equipment. You must not use or possess alcoholic beverages. You must comply with alcohol testing as your agent directs. You may not use or possess any controlled substances. You must comply with drug testing as your agent directs. That means it won't be as a matter of course necessarily. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, no contact with anyone you know to have a felony record. You may not change your residence unless you first get written permission from your agent. You may not possess a weapon while you're on probation. You must contact your agent or contact the probation department no later than the first business day following your placement on probation. You must comply with all the written and verbal orders of your agent, submit to a search of your person or property without need of a warrant, report any changes to your agent within 24 hours, and no contact with Kayla Ward, either directly or through another person. You may not be within 500 feet of her residence, school, or place of employment. No contact means of any nature, in person, electronic, written, etc. And you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It will explain that more on the form that we will send to you entitled, I believe, appellate rights, but we will send that out to you since you're not present in the courtroom today. So Mr. Stone, just remember that I did also say that you had to contact the probation department within 24 hours. That is important. So if you would make contact by phone with the probation department within 24 hours, they'll want to right away go through your conditions again with you and get everything set up. Do you have any questions?
No, Your Honor.
All right, then good luck, and that will conclude this hearing.
Thank you, Your Honor. Have a nice day.